Hello and welcome to KSG podcast. In this session, I would be discussing the important sections of the Contempt of Courts Act 1971. This topic becomes important because of the ongoing contempt proceedings against a lawyer of the Supreme Court. The Constitution in Article 129 and in Article 215 gives the power to the Supreme Court and the High Courts respectively to punish individuals with respect to contempt against itself. To regulate the procedure in this regard, the Contempt of Courts Act 1971 was enacted. The Act contains 24 sections, of which sections 2, 3, 4, 5, 10, 12, 20 and 21 are important. Section 2 defines the nature of the contempt of court, which can either be a civil contempt or a criminal contempt. Civil contempt means willful disobedience to any judgment, decree, direction, order, writ, or other process of a court, or willful breach of an undertaking given to a court. Criminal contempt, on the other hand, means the publication of any matter or the doing of any act which scandalize or tends to scandalize or lowers or tend to lower the authority of any court, or something which is prejudicial or interferes or tends to interfere with the due course of any judicial proceeding, or something which interferes or tends to interfere with or obstructs or tends to obstruct the administration of justice in any other manner. However, the Act itself defines certain things which, when done, will not amount to contempt of court. Accordingly, Section 3 says that innocent publication and distribution of matter is not contempt of court if at that time the individual had no reasonable grounds for believing that the proceedings were pending in the court. Also, the publication of any matter in connection with any civil or criminal proceeding which is not pending at the time of publication shall not be deemed as contempt of court. Furthermore, as per Section 4, a person shall not be guilty of contempt of court for publishing a fair and accurate report of an ongoing judicial proceeding. Likewise, a fair criticism on the merits of a decided case will not be deemed to be a contempt of court as per Section 5. However, as per the Supreme Court in Ashwini Kumar Ghosh versus Arvind Bose, criticism of court when going beyond the limits of fair and bona fide criticism will amount to contempt of court. Section 10 empowers the High Court to punish for the contempt of subordinate courts under its jurisdiction. However, if the alleged contempt is also an offence under the relevant sections of the IPC, then in that case the High Court shall not take cognizance of the contempt. An example in this regard would be Section 175 of the Indian Penal Code. Section 12 informs about the punishment of the contempt of court. Accordingly, a contempt of court may be punished with simple imprisonment for a term which may extend to 6 months, or with fine which may extend to 2,000 rupees, or with both. However, the accused may be discharged, or the punishment awarded may be remitted on apology being made to the satisfaction of the court. Principle of limitation is also applicable on such matters, and accordingly, Section 20 places a limitation for actions for contempt. In other words, a court cannot initiate contempt proceedings either suo motu or on someone's complaint after the expiry of a period of 1 year from the date on which the contempt is alleged to have been committed. Lastly, as per Section 21, the provisions of the contempt of court will not apply in relation to contempt of Nyaya Panchayats or other village courts. So this, in a nutshell, are the important provisions of the Contempt of Courts Act 1971, and I hope that the student find these information beneficial. Thanks very much.